This is a lecture from my professional responsibility class, and we're going to be talking about conflicts of interest and a new ABA formal ethics opinion that relates to a specific type of conflict. What happens when the lawyer on the other side of the case or the matter is someone that you're friends with or that you have a relationship with? So here we're talking about personal conflicts of interest and specifically friendships or relationships between the two lawyers in the case. So let's take a look at the slides here. So again, this is ABA Formal Ethics Opinion 494, and we're talking about conflicts that arise out of a lawyer's personal relationship with opposing counsel. So remember, we're talking about Model Rule 1.7 and specifically subsection A2, which prohibits a lawyer from representing a client without informed consent if there's a significant risk that the representation of the client will be materially limited by a personal interest of the lawyer. And a personal interest conflict may arise out of the lawyer's relationship with opposing counsel. So as a reminder, in some of my other lectures, I talk about personal conflicts being things like you own a lot of investments in the opposing party's company. So you might feel conflicted, or you have a personal history, a bad history, or a really good history with your own client that could create questions about your objectivity in the case, or are going to create problems in your client relationship, or a situation where maybe you have strong personal religious or political beliefs, and the issue that you've been asked to handle conflicts with your deeply held convictions. That would be another material limitation that we're concerned about. But here we're concerned about your friendship with opposing counsel. Now, when we apply this, this ethics rule basically breaks your relationships into three categories and that can affect your representation of a client. And the first is intimate relationships, what commonly may be called romantic relationships, but this is someone that you're involved with, friendships, and then acquaintances. So this is someone that you know each other, you've met a few times, you're friendly acquaintances, you say hi to each other, but you don't really know each other or spend that much time together. Now, intimate relationships, this part of the opinion harkens back to ABA 1.7 and specifically comment 11 that talks about family and marriage relationships. And that's already addressed by the ABA. Family and marriage relationships, they say you have to disclose to the client. You should probably question whether you should be handling the representation if the lawyer on the other side is an immediate family member. And certainly it would require client consent. What they're doing here is saying intimate relationships with opposing counsel, like cohabiting, we mean living together, engagement to the person, or an exclusive intimate relationship like boyfriend or girlfriend. This we're going to treat the same as we treat a marriage or sibling or family parent-child relationship for purposes of conflicts. These relationships must be disclosed to the client. The lawyers ordinarily may not represent opposing clients in the matter unless each client on each side knows about it and gives informed consent in consents in writing. That's in some ways the easy part of this opinion. This is the hard part. What about friendships? So friendships can be close or not so close. Friendships exist in a wide variety of contexts, the opinion says. So friendships have to be examined carefully. Now, close friendships with opposing counsel should be disclosed to clients, and where required as described in this opinion, obtain the client's informed consent. So this is a really strange part of this opinion, is that it seems to open up an intermediate category of personal conflicts for the lawyer that create a duty to disclose, but not necessarily a duty to obtain client consent in writing. And I don't see anything like that in Model Rule 1.7 or the big cases about it or ethics opinions, and the ABA on this particular point doesn't really offer any citations. And so traditionally, the rubric for personal conflicts of interest is you have the ones where it's really not a conflict and you don't have to disclose it and you don't have to get consent. And so it's so the conflict is so attenuated or so speculative that you really didn't need to address it with the client. Then we have the ones where there's a real conflict. You have to get client consent, but you can proceed with the representation as long as the client has been informed and consents. And then we have this kind of a case of extreme conflicts that the ABA calls non-consentable, where even if the client consents, your personal conflict of interest is so great that it was unreasonable for you to think that you could provide competent representation. But here we're opening kind of a new category of some conflicts you have a duty to tell the client about, but not a duty to ask for consent in writing. And if you're hoping for a bright line on the boundaries of this, the opinion doesn't give that. And so it's tantalizing in that sense that it seems to open up a new category of situations where the lawyer has intermediate duties of disclosure, but not getting consent in writing, and then doesn't really tell us where the boundaries are or give us a bright line rule for when that applies and when it doesn't. Now let's talk about acquaintances. By contrast, some friendships and most relationships that fall into the category of acquaintances need not be disclosed, nor must clients' informed consent be obtained. And so this is just someone that you kind of know and that you've known for a long time. You've known of them. You get along fine. You can chat a little bit about superficial things, civilities, let's say. You say hi to each other. And so things are cordial between you, but you don't really know the person, they're not close friends. Keep in mind that the opinion points out whether or not disclosure is required, you may choose to disclose a relationship to maintain good client relations. And it comes back to this point a few times. If there's a risk, there's always a risk if you don't tell your client, oh, I happen to know the lawyer on the other side. I've known them for years, and we're not close, but we say hi to each other. The problem is when you actually are with the client the first time that you encounter opposing counsel, they're going to be friendly and they might bring up whatever your point of connection is. Like, do you remember that time when we were in law school and we had that one class together or something? And so the client could feel like there's a friendship here or a history here that you should have told them about. So it's fine if you want to err on the side of being upfront with your client, but you don't have an ethical duty to. It just might be a good idea so the client's not surprised by something. Now, this is another interesting or kind of strange point in this ethics opinion. Consider the lawyer's role in the matter. A lawyer who is the sole or lead counsel in a matter is more likely to have a disqualifying conflict than a lawyer who has a subordinate or tangential role, such as researching discrete issues or drafting sections of papers to be filed, where that lawyer has little or no direct decision-making authority in the matter and minimal contact with opposing counsel. Now, again, I don't really see any language about this in the comments. The official comments to Model Rule 1.7. There are things like this in Rule 1.9, which is about former clients, Rule 1.10, which is about screening lawyers who come in as laterals from other firms, and Model Rules 1.11 and 12 about government lawyers and former judges, where they do talk about a category of where the conflict doesn't really matter if you had minimal involvement in a certain matter, or you weren't substantially involved, or don't have confidential information, and so forth. This spells it out in a somewhat different way. It doesn't give us a bright line rule again, but it seems to say that there are tiers of involvement in a case that then can create different duties for you in terms of the conflict, whether you have a disqualifying conflict and have to get client consent. And if you're looking for guidance for an MPRE question, I would say does the lawyer have a role in the representation where the lawyer has zero decision-making authority? Basically, are you just the summer associate who's writing a memo on venue selection or something like that, and you don't know really that much about the case? And secondly, do you have contact with opposing counsel? Because remember, this ethics opinion is all about the relationship between you, the lawyer, and the lawyer on the other side. And so if you're going to have zero contact with the lawyer on the other side, that also is a consideration here for deciding whether you need to get client consent. Now, the opinion mentions an earlier opinion, 488, that related to lawyers who are friends with judges and kind of references that and borrows some of the verbiage. So here's some close friendships that require disclosure and ordinarily consent from the client. Lawyers who exchange gifts every holiday. So is there somebody that you buy them gifts on their birthday? Who's at another firm, or for the end of the year holidays and the holiday season? Do you socialize together or regularly communicate and coordinate activities, maybe because your kids are close friends or your spouses are close friends? Do you spend time at each other's homes? Do you vacation together with their families? Are you a mentor and their protege, or vice versa? And or is someone that you share your confidences with and you talk to when you have a problem, and so forth? Anything where you're that close, where you really talk to them about what's going on with you, or you see them very frequently and spend a lot of time together, they're friends, right? And in that case, you have to tell the client, and you probably have to get the client's consent in order to proceed with the representation. By contrast, and this is this weird intermediate category that I think is new for the ABA, friendships that might require disclosure, but will not ordinarily require consent, and they just give examples, they don't really tell us where to draw the line, are lawyers who once practiced law together and may periodically meet for a meal when their busy schedules permit. Or they live in different cities now, but they try to meet up when one is in the other's hometown. And so if there's somebody that you really you used to be close to, but you haven't been close to in many years, but you try to keep in contact, and maybe you meet up once a year when you can make it work, that's something that they're saying maybe you need to tell the client, but you don't have to ask for consent and get it in writing. And then here's another example. You were law school classmates, or were colleagues many years before, and maybe before law school you worked together. And you may stay in touch through occasional calls or correspondence, but not regularly see one another. And this will typically not require the consent of the affected clients. And if it's really a distant relationship, you've really grown apart from the person, at some point it doesn't even require disclosure. You're just an acquaintance, someone who's in the past you used to know, kind of. Now, whether consent or disclosure is required depends on the lawyer's considered judgment as to whether 1.7A2 applies, and if so, whether the lawyer reasonably believes the lawyer can competently and diligently carry out the representation, notwithstanding the client. And this is exactly what the rule says. And so this part should feel familiar to you if you're really familiar with Model Rule 1.7, is it has to be reasonable for the lawyer in that situation to think that they, in spite of whatever the personal conflict is, that they could still provide competent and diligent representation and get the client's consent and so forth. Now, again, we're almost near the end here. Some friendships and most relationships fall into the category of acquaintances and do not need to be disclosed even or get the client's informed consent. And so a true acquaintance is someone that maybe you just, again, see from time to time. They live in your neighborhood. So when you're out for a walk or something and you see them, you can greet them by name, let's say, and maybe you stop and chat about the weather or things like that, but you aren't really close. They give other examples in the ethics opinion. You go to the same gym as this person. So you pass each other at the gym, say hi, you know each other, maybe you make conversation and make small talk, but that's a little different from really being friends. Or if you go to a church or a house of worship and it's a large congregation, maybe they go to the same congregation as you and you greet each other when you see each other, but you don't really like go over to each other, have dinner together or lunch together or spend any time kind of opening up and talking about your lives. And keep in mind that even if disclosure is not required or mandated, you may want to do it just for the sake of building trust with your client or to avoid surprises later on. Yes, I know this person. We go to the same gym, or we go to the same church. We're not close, but I know who they are. We make small talk sometimes. And just so the client knows the nature of the relationship when they see you making small talk with opposing counsel. Okay, that concludes our lecture on ABA Ethics Opinion 494, which relates to Model Rule 1.7, conflicts of interest.